and I also proposed 3 amendments to Bill C-9. 2 of my amendments were passed at committee, with the third narrowly defeated by a single vote. The first of my amendments to pass was incorporated laypersons, Canadians who are not lawyers or judges, into nearly every stage of the judicial conduct process. This dovetails with the legislative objective of increasing public confidence into the justice system and improving public accountability. Our committee heard substantial evidence supporting this idea. Professor Richard Devlin of the Canadian Association for Legal Ethics agreed with the need for increased representation of laypersons, stating that the values of impartiality, independence, and representation are compromised without sufficient lay representation. He also raised the concern that the proposed Section 115 of the Act suggests that reduced hearing panels might not be public. Professor Devlin said that a judge could potentially choose to avoid any lay engagement at that stage of the process and have it in private. The Ontario Judicial Council Registrar, Alison Warner, told us about the advantage of having layperson involvement in their provincial judicial conduct system. She said laypersons offer, quote, quite an invaluable perspective in the deliberation process, unquote. The representative from the Canadian Judicial Council did not agree, saying that she didn't think, quote, it's necessary at every stage because you don't see it everywhere else within an administrative tribunal, nor not at the screening stages and not at others, unquote. Responding to that, I pointed out that the federal process has much more in common with similar systems at the provincial level, including the Ontario Judicial Council, than it does with different administrative tribunals. And given the degree to which judges hear very important cases dealing with the public and the ramifications of those cases, it's important that Canadians feel like they are represented in and can trust these processes. Those are important reasons to involve lay people at every stage. Some may question whether laypersons have the requisite legal training to sit on a quasi-appeal board. First, the lay people the Council would have in their roster would be appropriate people and receive the necessary training to do the job they are required to do. Secondly, contrary to the belief of some, and colleagues, I say this as a lawyer, lawyers don't actually know everything. And laypersons can bring a valuable common sense perspective to disciplinary matters. And third, if you are uncomfortable with a layperson dealing with matters involving the law, I'd suggest that our Senate Legal Committee would be very different if only lawyers and judges were allowed to be members of that committee. People who are not lawyers or judges bring a different lens to legal matters, and where issues of judicial discipline can so impact public confidence in that system, it is important that laypersons be involved in the process. Senator Clement cited an example at committee from her own experience. She said, quote, when I appear in front of the Workplace Safety and Insurance Appeals Tribunal, I'm using an administrative law example, when they have 3-person panels, the chair is a lawyer and the employer community is represented, and the employee or union perspective is represented. In my experience, they are triers of fact, but they also render decisions that deal with the law. It's considered quite a good tribunal in Ontario, quite an expert tribunal. It has an excellent reputation. The lay people on those panels have training, they have encadrement, as we say in French, and they have support. I would say the quality of those decisions is good, unquote. Furthermore, after my later amendment passed at the Legal Committee, Bill C-9 now contains the ability to appeal to the Federal Court of Appeal. This court could therefore handle judging the finer points of law if required. Ultimately, my amendment to include laypersons at every stage of the judicial disciplinary system passed soundly at committee, with 8 members voting in favor, 4 against, and 1 abstaining. Several expert witnesses at the Legal Committee called for the inclusion of the Federal Court of Appeal. These included the Canadian Bar Association, the Advocate Society, and political science professor Caroline Dick. The Canadian Superior Judges Association, 1,200 members strong, as Senator Dalphon stated today, also sent the members of our committee a letter indicating that by the end of the government's consultation period, they were not in consensus with the position of the Canadian Judicial Council on the issue of external review. This Judges Association stated that they were, quote, in favor of a judge's ability as of right to seek a remedy at court on the issue of the conduct review process, unquote. Notably, among the witnesses supporting inclusion of the Federal Court of Appeal was the Canadian Bar Association, which represents 37,000 lawyers, Canada's biggest legal association. During the 10 years I have been a member of the Senate Legal Committee, I can't recall another time that we have had the President of the CBA testify before us. The CBA sometimes suggests amendments, but it is uncommon for them to suggest major amendments to government bills. But when CBA President Steve Bugeaud appeared before us on Bill C-9, he provided two important reasons for including the Federal Court of Appeal as an option to appeal to an actual court before the Supreme Court of Canada. Quote, "First, as a matter of natural justice, it ensures that there is external oversight to the process. Second, the judiciary is so important to Canada's democracy that the public must see that judicial discipline is carried out in an open and accountable manner with clear avenues of appeal and redress. Another benefit of a right of appeal is that the Federal Court of Appeal is likely to give detailed reasons, so the judge accused of misconduct and the public would then know why an independent court concluded the way it did. This enhances the Canadian Judicial Council's credibility by the transparent review of its process and decision-making," unquote. Mr. Bugeaud also said, quote, "To conclude, the judicial branch is the pillar of our democracy and must be accountable to and accepted by the public. By creating a clear, open process for judicial discipline where the Canadian Judicial Council's actions can be meaningfully appealed to an appeal court, and by having review proceedings conducted in open court, the public retains confidence in the judicial discipline system's integrity. Justice will be seen to have been rendered," unquote. Even now, with the addition of the Federal Court of Appeal, the amended Bill C-9 would still be a major streamlining of the process. The current process can involve appeal of a panel decision to the Federal Court, then the Federal Court of Appeal, then to the Supreme Court of Canada, with leave or permission. The bill as amended would still eliminate a full level of court, thereby saving both time and money, but it would retain the principles of fairness, transparency, and accountability. It is important to note that with this bill, the Trudeau government made a conscious choice to extend the ability to appeal to the Supreme Court of Canada by leave rather than by right. As it is, the Supreme Court of Canada only grants appeals in 7 or 8% of the applications for leave it considers. Further, the Supreme Court must deem a matter to pass what it considers the national interest test. There is certainly no reason to be optimistic that an issue of judicial discipline would meet that criterion. Even senior Department of Justice official Patrick Xavier admitted 4 times during his testimony that they do not know whether the Supreme Court of Canada would grant permission for this type of judicial disciplinary conduct appeal. As Mr. Xavier stated, quote, "We don't know yet what the court will do. It's an open question," unquote. Where a judge facing investigation for misconduct is the Supreme Court of Canada justice, there is an extra level of complexity. As CBA President Steve Bugeaud testified, quote, "The fact remains that if the judge under investigation is a Supreme Court justice, it's a complex question of law. Can the rest of the court sit in a judgment of appeal by a colleague, and can enough judges who do not already have knowledge of the facts be assembled to have a quorum? It's a pretty complex question, one that would perhaps be less of an issue in the Federal Court of Appeal, since there are enough judges to assemble a 3-judge panel," unquote. The Advocate Society also proposed adding the Federal Court of Appeal back into the judicial conduct process. Sherry Conlon, executive member of the Advocate Society, testified, quote, "The Advocate Society is concerned that Bill C-9 creates a legislative scheme in which the Canadian Judicial Council is the investigator, the decision maker, and the appellate authority with respect to allegations of judicial misconduct. In the end, external judicial oversight of the CJC's decisions and actions is all but eliminated. The proposed process is concerning because court oversight of administrative actions is fundamental to ensure their legality and fairness. The lack of court oversight of the CJC's process undermines the security of tenure of the judiciary, which is a critical component of judicial independence. We must stress that we believe our proposed amendment will not reintroduce delays and costs we see in the current process, which the government is rightly trying to fix. The proposal ensures that only the CJC's final decision will be subject to appeal directly to the Federal Court of Appeal. This will eliminate one layer of judicial review, the Federal Court," unquote. Ms. Conlon went on to say, quote, "We believe the small change that we propose to Bill C-9 strikes the right balance between efficiency, public confidence in judicial accountability, and fairness to all parties, all while maintaining judicial independence, unquote. With these key considerations and significant testimony about this issue, I am pleased our Senate Legal Committee passed my amendment to reinstate the Federal Court of Appeal as a final level of appeal before seeking leave from the Supreme Court of Canada. Reintroducing the Federal Court of Appeal into the disciplinary process could have another advantage. Having a court rather than a panel as the penultimate appeal level offers significant precedential value as well. An actual court, not just a panel, but an actual court, is an advantage for determining intricate matters of law that may arise from these matters. In any case, my amendment to reinstate the Federal Court of Appeal into the process as an avenue of final appeal before applying for leave or permission to the Supreme Court passed at Legal Committee by a vote of 7 members in favour and 6 against.